Hello, this is Matthew Chan. Welcome to the newest episode of Courtroom Strategy with Oscar, Michelen, and myself. We are excited about this brand new episode. And in this episode, we're going to talk about protecting ideas. So, Oscar, how are you today?
Good. Good to see you, Matt.
Well,
how are you doing?
Great. And I noticed you've got a casual look today.
You know, it's funny. The other shows, we were talking about more kind of lighthearted fare. I was in my traditional litigator's suit. And now here we are going to be talking about trademark law and copyright law, and I'm in my, casual suit. But just, I had a free court date, and if I'm not in court, I can kind of keep the tie out. No client meetings, so it's all in-office work today. I can cash out a little bit.
Well, we like to think that the talent lies within the person and not the suit, right?
Yeah, it's like Samson, cutting your hair, you lose your power. Take my tie off. I can't think like a lawyer anymore.
Okay. Well, in preparing for the show, one of the things I like to do is read over your blog and courtroomstrategy.com, and I really liked one of your articles. It had to do with protecting ideas, and I know you wrote it in the context of a reality show. But, protecting ideas goes beyond just reality shows. It could be inventions, ideas for a book or whatever, so many things in life. So, anyway, why don't you kick this thing off about protecting ideas? Are ideas really protectable? Just because someone has a great idea.
Yeah, it's a very, very wide topic. So we're going to try to, cover it as basically as we can. I mean, obviously, there are whole law school classes devoted just to intellectual property, and then there's whole classes devoted just to copyright, then just to trademark, then just to patent law, then just to trade secrets, all of which are about protecting ideas. But we're going to try to generally sum it up, starting a kickoff from what basically my blog post was about, which is that, I've worked with artists and personalities and getting them, reality TV shows, negotiating it with networks and things of that nature. Mm-hmm. And clients are always worried about when they have these great ideas for submission to either television networks or to production companies. How can I protect my idea? How do I know that I'm just going to steal it from me when I submit it? And the easy answer, of course, is that, you can write out a non-disclosure agreement, confidentiality agreement where they'll agree to sign on.
Right.
But folks will be kind of disheartened when they see back that most networks have their pre-produced forms for that.
Yeah.
And what they'll say is, look, we're not going to steal your name. We're not going to steal your logo.
Yeah.
Those types of things. But we can't promise you that we haven't already thought up of something along the same lines, or that we don't have in development something similar. So that if you see something down the road, don't come and sue us just because it sounds a lot like your idea. It probably wasn't your idea. And more importantly, you should be aware, these forms say, that ideas aren't protectable. It's the creative expression of an idea that's protectable. And what I tell clients, what I think is good for our little 20-minute or half-hour discussion on protecting ideas is the copyright law is meant to protect your version of your idea, not the idea itself.
Right.
And so the best way that I could put that out is, let's go in each kind of little area. So for inventions, right?
Yeah.
Which normally is the field of patent law.
Okay.
Maybe you come up with a great way to keep your food warm or cold throughout the day, and you've seen these new ideas that have come out, which are these bags with like aluminum foil that are part of it, and I guess because of the economy, more and more people are starting to bring in their lunch and not going out. And all of a sudden, I've seen even my own staff come in with different versions of these little bags that protect your food from getting warm or cold, depending on what you want.
Okay.
Throughout the day. So let's say somebody comes up with this idea. Oh, I got this bag, and I'm going to figure out a way to keep aluminum foil within the bag, so it still looks good, but it protects it from the hot and the cold.
Right.
So that's the general idea.
Correct.
Okay? So now I come out with a product that does that. Okay? And I call it something. I don't know. Pick a name. We're going to make it up right now. Lunchy Freeze or something like that. Okay?
Mm-hmm.
So that doesn't stop, Ronco or HSN or QVC or anybody else that produces products for sale to say, oh, wait, I got a better idea. That's a great idea. People are bringing their stuff to work. Let's come up with a different version.
Yes. They
can come up with a different version. They're not, and you can say, wait a minute, I came up with the idea of a bag that protects people from hot and cold. You can't control that idea.
Right.
The idea of a bag that controls hot and cold. The way you do it, the specific way that you do it, and the name and the trade dress, how it looks, you can protect. The design of it, you can protect through a design patent. And that particular version, you can protect through a patent. If it's novel, if it's innovative, if it uses new technology, you can protect it through a patent. If you like the name Lunchy Freeze, you can trademark the name Lunchy Freeze.
Yeah.
Okay? And so you can protect those certain things, but it only goes so far. And that's what people need to know is they need to lower their expectations of what can be protected and what can't be protected.
Well, I'm glad you clarified that and the reason why I was particularly interested in this topic, not because I'm going to have a reality TV show, but, over the years, I've run into so many different people. They said, well, I had an idea for this, and they stole my idea, or they took my idea, and they think that just because they came up with the idea, no one else could come up with the idea. And the fact that they own the idea, all of a sudden, they've got a monopoly on it. And I guess from my point of view, they don't take into appreciation what goes into making into reality an idea. It's one thing to have an idea, as you said, in a lunch, have this idea for this gadget to keep your lunch cold or warm, but it's a whole different thing to actually carry it out and make it real into some format, as you say.
Correct. Right.
I guess you call it creative expression of it.
Right. The copyright law and both the patent law require you to be able to put your idea into an identifiable, protectable format, okay? So you can't just have this generic idea and write to the Copyright Office and say, well, no, what's your expression of that idea? So, for example, let's talk about the reality show, okay? What you do with that is you come up with the idea, okay? And let's say, for example, the idea of Wife Swap, which is a reality TV show. So that we'll have two women from different backgrounds live in each other's home for a week, and let's see how they do. We'll have a neat freak in the home of a slob, and we'll have the slob in the home of a neat freak. Okay.
Right. That's the
why people watch it, I don't know, but it does it. Okay. So you want to protect that idea. You want to write a network. You can protect that. Okay. So you have the name Wife Swap. Okay. You get a trademark for a reality TV show about this. So now no one else can do a show with that name.
Yeah.
Okay? But that doesn't mean that I can't open up a restaurant and call it Wife Swap.
That's right. It's a whole different category.
For a particular, right. Okay.
Okay.
So until that name develops a secondary meaning where you only think of it for that company, you can't protect your name. For example, under no circumstances could I open up a restaurant and call it Exxon. Could I open up a restaurant and call it Nike?
Right. They're too pervasive, right?
Yeah, because people are going to think. They're going to think that that's Nike. I wouldn't open a restaurant and call it Exxon. That's a bad example. But, when I call it BP, I'll really do well. But you get the idea, right? So, but I might open up a restaurant and call it Nike.
Yeah.
Right?
That's
because
cool
people
brand.
affiliate with Nike and say, hey, I might come in and, there'll be Nike. Well, there'll be... Right, so it's going to be associated with that company. You can't do that. But Wife Swap, it doesn't have that. You can open up a restaurant and call it, Wife Swap. So, but You then write out the basic premise of the idea, which is a treatment. It's called a treatment. And you can copyright that. And therefore, they can't take that same treatment and use it. The word-for-word version of it is what I mean. You can register it with the Writers Guild of America and get a WGA number. So that sends the message to the network that you've thought this through and you've tried to protect it. It makes it less likely they're going to take the exact writing of what you did and do something with it. Okay. But then now, let's say the show becomes popular.
Yeah.
Any network can now open up another show.
Yeah.
And call it, Home Switch, let's say.
And still have the two women trade off.
And have the basic premise, the basic idea.
And that is allowed, right? I mean,
that's probably allowed.
Yeah.
It doesn't mean, well, look how many reality shows that are similar, right?
Yes.
That have Deadliest Catch, Coal, dirty jobs. It's all the same premise. Let's follow some people with crappy jobs, be thankful we don't do it, and see what their day is like.
Yeah.
That's the general idea, but people's different variations of it are protectable. I can't open up I can't do a show called Deadliest Catch and show a dog catcher who catches pit bulls.
Yeah.
Okay, because Deadliest Catch is, pretty much a recognizable trademark for that type of TV show. But I might even, believe it or not, you can get even close. I might even be able to have another show called Deadliest Catch in a whole different area.
Yeah.
I could do a movie called Deadliest Catch as long as I can show that I'm not trading on it and has nothing to do with the show at all. Maybe it's about, someone trying to get married or something.
Yeah, that was exactly what I was thinking. Some lunatic relationship. The Deadliest Catch.
Exactly. So, it's a whole different type of thing. Yeah. So people have to know their expectations, that they can only do their own version of that idea. So the first thing that you need to try to do is try to say, what's unique about my version of the idea? What is my expression of it? Think it through. Don't just say, I got this great idea, and then, try to go get it sold. First of all, you're not going to get a seller because they're going to want something concrete and marketable and able to put out in the marketplace. Okay? Otherwise, why do they need you?
Yeah.
And then secondly, it requires you to flesh your idea out and think about what becomes the unique version of it, so that you can bring it to market and control it. Mm-hmm. And it also kind of, I hate to say this, I say this to clients many times, it also kind of forces you to maybe realize it ain't that great an idea.
Because they actually have to think it through in much more clear thoughts.
And it's been done. Yeah. And it's been out there. Yeah. And it isn't that original. And it isn't that creative. And it really is just, kind of somebody else's idea or something that's been done 1,000 times before or is already in the marketplace. That's one of the other great reasons why when clients come to us to trademark things, we tell them we've got to do a national, trademark search, depending on the product and the idea, obviously. Yeah. And the reason why that helps is because you may not be aware that someone's already done this.
Yeah.
And you're going to go out there thinking it's all fresh and new and then see somebody's already got 50 stores selling this product or using this name for a line of, dental services or, cold creams or which are things that I've actually worked on and we've seen. Now, we've had clients who've opened up restaurants and, they have received letters from restaurants in California saying, hey, we're called X, you can't do that. And we've been able to successfully say you can't control that name for the whole country. If you're not going to be coming into New York, two restaurants with the same name can exist, one in California and one in New York.
That's a great example.
Right. and as long as I'm not taking your logo, I'm not taking your menu, I'm not trying to make people think that I am you, then I'm going to be pretty much allowed to do that. Now, I may have a problem, by the way, if they decide they do want to expand and come into New York. You're allowed to come in and say, hey, guess what? I want to come into New York now, and I've got my 15 restaurants across the country, and your name is the same. I may be able to force you, even though you've used it first in New York, to put a disclaimer on there. And if it's too similar, and if it's too similar in certain circumstances, even though you've used it in New York first, I may be able to stop you from using it.
Is that right? That is interesting.
Because I used it first around the country, and I have been expanding to other areas. If you did a valid trademark search, you would have seen that I am using it in other states, and so you're on notice that it's possible. Because chances are, if I've got my restaurant in 4 or 5 other states, I've got a national trademark. That's why you register trademarks, Matt. Yeah. That's what we're talking about. That's why you do protect your idea of a name the best way that you can, which is by registering it. So that now, when this genius decides to open up a restaurant in New York with a name I've already got in California, it came up. So we were aware of it, okay?
Yeah.
We were aware of it, and he wasn't able to register the name in that fashion. And he said, you know what, I'll take a risk. I'm going to open up my own restaurant, okay, and see what happens. But if you see that you can't register with the trademark office because they've got 5 restaurants across the country, the trademark office is going to warn you about it. So you're on notice. So now 6 years from now, even when they expand into New York, you're going to probably have to change that name.
Right. Well, let me ask you something here. I hope this doesn't put you on the spot, but you kind of alluded to it, how there's people that want to come in and use your services. Now, again, this is not meant to be a put on your spot, but when the people come in, do you actually feel like that your service is actually in need in some of these situations? Have you ever had to tell them, hey, look, your idea is not that original. I can do this for you if you really want me to. But my heart's not in it,
Right. If you're
going to be protected.
Look, there's lawyers and then there's lawyers. Okay. So, you could walk into a lawyer's office who's hungry.
Yeah.
And he may think your idea is completely not trademarkable, not copyrightable, not protectable, and still take, your $600 to file the application. When it gets denied, say, oh, well, I tried, but guess what? My family and I get to eat this week. So, you got to be careful who you go to. You got to try to go to someone, is a little bit established. You want to do some of your own homework yourself. So first of all, the trademark office and the copyright office have very user-friendly websites that you can copyright your own stuff and you can trademark yourself pretty much, okay? You really can. What a lawyer does is increases... I'm very serious about it.
Because I've heard some things to the contrary.
What's that?
I've heard some things to the contrary. They're real fussy, and if you don't do it just right, it'll be tossed out.
Right, so guess what? It gets tossed out, but they explain to you why.
I see. And
then you correct it. Right. It doesn't cost you any more money. They don't just say your trademark is denied, go figure it out why.
I didn't know that.
No, they send you back a letter and says your trademark is denied because these prior marks exist or the words are too generic. You can't call yourself New York Laundromat and trademark that. You ain't going to get that.
Yeah, right.
Right, so they'll tell you why. And they have standard boilerplate answers that will explain it to you why. Now, I have had many times where folks have come to me and said, no, I tried to trademark it, but I couldn't. And they show me and said, no, we can fight that. Okay, so you can have good lawyers that try to explain. The trademark office has a lawyer that reviews it. So if a lawyer comes back and says, oh, wait, I think you're wrong for these reasons, they'll look at it. And they might say, you're right. Well, you know what? We'll give you a trademark with a specific geographical limitation on it. Or get the consent of that person in Jersey, and we'll let you do it. So there's things that you can do to help get past that. That's what lawyers can help you to do. But if your idea is already unique enough and no one else has it, you're going to pay your fee, a couple of $100, and they're going to say, congratulations, you're registered. And the same with the Copyright Office.
Right.
For example, I could take a book that's already been copyrighted. Okay? I can change the title. And I can copyright that with the Copyright Office. They're going to give me the copyright. They're not going to read the freaking book and try to see if it's been written before. Okay?
Okay.
Now, is it a good copyright? No. It's not enforceable. But what I mean by that is, if you have an original piece of material that you have written, you can submit it to the Copyright Office, and they're going to just accept it. And then it's for you to worry about whether it's enforceable or not.
I see.
So if you have an enforceable idea by a song, any written expression, you can do your own copyright. It's those people who are either on a gray area or may not be able to prove it's theirs that are going to have trouble through the Copyright Office. So what I tell clients is to save them money. You can also go on the website of the USPTO, uspto.gov, and use what's called TESS, which is Trademark Electronic Search System.
Okay.
So, for example, let's say you want to have this thing called Lunchy Freeze.
Okay.
You can type in Lunchy Freeze, and it will show you every trademark that has those words in it. You can even do lunch asterisk freeze asterisk,
or
great. Freez asterisk.
Okay.
And it'll search Lunchable Freeze. It'll come back with Lunch Freeze, Lunchy Freezing, anything that's extension of that core word. And that's for free, by the way. You can do that for free.
Now, what does the PTO stand for? Patent and
U.S. Patent and Trademark Office. Copyrights are handled by the Library of Congress and the U.S. Copyright Office.
I think it's copyright.gov. I think that's
copyright. I think that's copyright.gov.
Okay.
That's correct. If you put in the word copyright, I'm feeling lucky, you're going to get there with Google. Google, by the way, is a trademark. So then you have the USPTO, which handles patents and trademarks. Two separate things, the Trademark Office and the Patent Office. But they're done through the same website and the same office.
Okay. Now,
if you have an idea that's a fixable invention type idea, that's a patent, and you need a lawyer who is admitted to the patent bar.
Oh, is that right?
Yeah, I can litigate patent infringement. I cannot get somebody a patent because I'm not a member of the patent bar. In order to be a member of the patent bar, you have to get a BS in one of the sciences. And had I known that, I would have gotten a BS in biology at school as opposed to psychology, which is a waste. And I could have been a member of the patent bar, but I'm not going to go back now and get a BS in biology just so I can do patent work.
Right.
But so you have to have a BS, and then you have to pass the patent bar.
Very interesting.
So, yeah, you do need to find a patent lawyer or a patent agent for that. But for trademark, any lawyer can do it. Copyright, any lawyer can do it. And so the difference is a copyright are words and, a song, a book, a play, a treatment for a show, maybe even ad copy if it's original enough. But again, certain things are not copyrightable. For example, You can use a quote from a book.
It's fair use, right?
It's not fair use. It's actually just not protectable. It's not enough.
I see.
You have to take fair use as a defense to copyright.
I got you.
And so you can use fair use for education. You can use fair use for parody when you're making fun of something. That's why Weird Al can take somebody's song and make fun of it because he's making fun of that actual song.
Satire.
I can't. Right. But satire you have to be parodying or satiring, making satirical use of the thing you're making fun of. I can't take a Michael Jackson song to make fun of the TV show Friends.
Really?
You understand?
Okay.
Yeah. That's just stealing Michael Jackson's music.
I gotcha. Hello, audience. We had a little bit of a technical glitch there, so we've gotten a little bit off track. But if I recall where Oscar was speaking, as he was talking about the copyrights and the patents, and he was talking about the quotes. So, Oscar, I know we got a little derailed here, but we will attempt to try to wrap this episode up, which is where we were at before we got cut off. So, anyway.
Just quickly what I was just talking about, Matt, was that, when you copyright something, you could use a quote, and since you're not taking a large part of the book, chances are that you haven't infringed on the copyright of the person who wrote it. And, like very similarly, you can't copyright a slogan or a quick, even, let's say, few words that might be, catchy. Like a catchphrase.
Like, be all that you can be? We can't make it.
It's a perfect example.
Let's do it?
That's a perfect, just do it.
Oh, just do it, sorry.
Those are perfect examples. Okay.
Cannot trademark those, huh?
What? No, wait a second. I said you can't copyright them.
Oh, you can't copyright them.
Because they're general English words.
Yes, they are.
That you didn't come up with. Both be all you can be and just do it were phrases that were in the English lexicon before the Army.
That's
and
true.
before Nike took them. So you can't copyright them, but you can trademark them. And the way you have to trademark them is they have to acquire something that's called secondary meaning. And as so often in law, you may not be aware that there are legal terms that apply to common sense things. Like you just said, well, wait a minute, how can you not protect it? I know that be all that you can be means the U.S. Army. And I'm not going to get into the fact whether the government can own copyrights. That's a whole other class. But
right.
So, or just do it. Well, why can't I just start using that in my advertising? Why? Because what Nike did when it decided to just do it, it launched it in a monster campaign.
Yes, they did.
It put it on all of its tags, on all of its clothing as well. People don't realize, why did they put just do it on the labels? They put it in every ad that they had, and then they had a multi-million-dollar ad campaign. Because what they wanted to do was acquire secondary meaning in a very quick fashion.
That's very good. Secondary meaning. I've never heard that before, Oscar.
What it means is that when you hear the phrase, you no longer think of the phrase. You think of the company.
Yes, you do.
So that the phrase has acquired secondary meaning in the marketplace and that it means Nike. It doesn't mean just do it.
Yeah.
Right. So that means I can't use it for my advertising purposes.
Yeah.
Okay? So it's got to acquire that secondary meaning. That's a protectable idea. It's an expression, not a trademark, and it means it's my business. The same as the swoosh means that's my business. When you hear just do it, you think of my company. You don't think of the words. Got milk is another one.
Yes.
Okay, now it means the American Dairy Farmers Association, and that little ad with the white milk mustache, okay?
Yeah.
So you can acquire that secondary meaning over time in your company by using it in the marketplace. You can't spend it the way Nike does, but if over the course of time your little phrase has come to mean your little business, you can protect that. So the way to wrap it up, I think, in a nutshell, is if you come up with this great idea, think of the way that you want to express it. What's unique about it? Write it down. Record it on a CD and an MP3 if it's a song. Take a picture of it if it's a logo. Save it on your computer, whatever. And then either by yourself or through a lawyer, find the right way to express that idea's originality, and then protect it, either through a copyright or a trademark, or if it's an invention or a design, through a patent. And chances are you'll increase the protectability of your ideas. So, keep working on them, because all great businesses, songs, music, books, inventions are protectable intellectual property if you know how to get it done right. So I hope it's been informative, and it's been a kind of a quick little primer on intellectual property, which is a great area of law that I love to practice, and it's always very interesting.
Yeah.
And I hope it's useful to those of us who are watching the show. Yeah,
definitely. Well, my closing comments are that one of the reasons why I think you and I enjoy doing this show so much, even though we don't get any compensation for doing this,
right.
We just kind of donate our time. In fact, we're doing this after hours, is that, there's so much, we don't ever script the shows. We never know what's going to come up. Yep. Certainly we didn't plan the technical glitch that came up. But in the course of doing these episodes, like we were talking about protecting ideas on a reality show, but as we discussed it, I mean, this really does have far-reaching impact and usefulness, for that matter, for so many people. So I think a lot of people are going to enjoy listening to this episode. And who knows, we may actually do a follow-up on this, because there's so much to talk about.
Oh, absolutely. It's a very wide-ranging area, and it's also one of the things that people don't think about and need to think about when they're starting a business or coming up with an idea.
Yeah. Okay. Well, good.
Okay, great. Good talking to you.
Yeah. Thank you, Oscar. On behalf of Oscar and myself, we appreciate you joining us on this episode, and we will catch you on our next episode. Thank you.